Welcome to all of you who are joining us for today's webinar on representing transgender clients in family law. My name is Jennifer Levi, and I'm the director of the Transgender Rights Project at Gay and Lesbian Advocates and Defenders. I'm delighted to be joined today by my co-presenters, attorneys Ben Jerner, Shannon Minter, and Polly Crozier. Regrettably, Spencer Bergstedt's unable to join us today, but I'll be filling in to present material he would have covered. First, I'd like to thank the co-sponsors of today's webinar, the American Bar Association's Commission on Sexual Orientation and Gender Identity, as well as the ABA's Family Law section, and the section on individual rights and responsibilities. And I'd also like to thank the National LGBT Bar Association. The format for today's webinar will be that each presenter will give 10 minutes of remarks, followed by a question and answer period at the end of all of the remarks. Because of the large number of attendees, those of you listening will not be able to directly pose questions to the panelists. However, I invite you to submit any questions to me using the chat function. To do so, please type your question into the question box in the control panel on the right of your screen. If your control panel isn't open, click the orange arrow to expand it. It's now my pleasure to introduce Ben Jerner, who is the managing shareholder of Jerner and Palmer. His Pennsylvania, New Jersey-based practice focuses heavily on legal issues affecting LGBT clients, and he's going to be giving today's introduction to representing transgender clients in family law. But actually, I'm going to introduce all of the presenters, and then I'll have Ben begin. So following Ben, I will be talking about changing gender designations on identity documents. Following me will be Shannon Minter, who is the legal director for the National Center for Lesbian Rights. He's one of the nation's leading advocacy groups for LGBT people. He will present on two topics: family formation, protecting transgender clients' parental rights, and custody disputes involving transgender children. Following Shannon will be Polly Crozier, who is a senior associate practicing family law at the law office of Joyce Kaufman in Cambridge, Massachusetts. Polly is also co-chairs the Massachusetts LGBTQ Bar Association and will be presenting on transgender parents' rights after relationship dissolution. So turning first to Ben Jerner.
Hello, my name again is Ben Jerner, and I'll be discussing just sort of generally the ways in which you can provide representation that's effective and that's also as comfortable as possible for transgender clients. Due to some time constraints that we have today, I don't have time to define all of the key terms related to gender identity, expression, and transition. But you should be aware that the term transgender is an umbrella term that encompasses a wide variety of people whose gender identity and expression doesn't conform to sort of traditional norms. For example, it includes people who may medically or sometimes surgically change their bodies to make them more in line with the quote-unquote opposite sex. And it also includes those who don't wish to change their bodies but might feel that their gender identity is more in line with the other sex than that which they were assigned at birth, or who may feel that they're both male and female or neither male or female. You should always ask a transgender client what language they would use or how they would identify themselves, as there is a wide variety, and everyone's got their own term that they may use to describe their own experiences. Initially, we can go to the next slide now. Making your office welcoming and respectful starts with education, both educating yourself and your staff about transgender issues and transgender people's life experiences. One of the best ways to do this, I think, is to have someone come in to do sensitivity training who specializes in this area. And there are also a lot of good resources online, from handbooks dealing with working with transgender clients or staff to blogs by transgender people who share their life experiences, just to be able to gain a little bit of understanding there. And at a minimum, you and your employees need to come away from whatever training you can do, understanding that some clients may be transgender, and that all clients' gender identities and expressions need to be respected. There's several ways that you can signal to people that your office is welcoming of transgendered clients. The first is to make modifications to your intake form. This can take the shape of everything from asking for, instead of asking for someone to check male or female, instead having a question that asks for gender and a blank that people can fill in. You can also, instead of asking for someone's name, you might ask what their current legal name is. You can also ask them what name they would prefer to be called. Another thing to put on intake forms is asking if there are any special instructions that the client might have or needs the client might have in terms of discretion with communications. For instance, if you may have a need to call a client at work, that client might not be out to their employer that they're transgendered. They might want you to use their birth name or the pronoun that they were assigned at birth instead of their new pronoun and new name when you call them at work. So just asking them on the form if they have any special needs in terms of communication can be helpful. Another important way to make sure that your office is welcoming is to implement a restroom policy that is comfortable for people who are transgender. I think one of the best ways to deal with this is to have, if possible, a single-stall, gender-neutral bathroom. If that is not possible in your office, then I think the next best thing is to have a multi-stall bathroom, but that's just designated a family restroom. These are sort of popping up more and more, and they're not gendered, and there's lots of benefits to them, not just for transgender people, but also for people, say, with disabilities who may have helpers that are of the opposite sex that may need to use the restroom with them, or even if there's diaper changing facilities, it's very helpful sometimes for fathers of young children, as those diaper changing facilities are often not in men's restrooms. And whether or not you implement either of those two suggestions, your staff needs to understand that the gendered restrooms that you do have, if that's whether that's all you have or whether you have that in addition to these other types of restrooms, that the restrooms will be available to staff and to clients based on their own gender identity, not based on their birth sex. And finally, you can adopt office and employment policies that demonstrate your commitment to transgender rights. This can be, for sure, your anti-discrimination policies, making sure that those policies state that you don't discriminate on the basis of gender identity or expression, and can also include, where it's available, having health insurance that provides for treatment for transgender people. And if you can publish these policies online or in your firm's promotional literature or whatever it is, all the better, just to make sure that people know that you're supportive of trans people and trans rights. Okay, next slide, please. So learning about transgender people is not only important to providing a welcoming environment, but it's also important to providing effective representation. You need to understand, the terms that you may run across in the case law. It's also important to be aware of that case law or any statutes in your jurisdiction relating to the legal status of trans people, and specifically relating to transgender people and family law matters. Where the law is lacking in your jurisdiction, you may also need to look outside your jurisdiction to see how other courts and other jurisdictions have dealt with particular legal issues. Another thing to be aware of in terms of making sure that you're being an effective advocate is being aware of any internal bias or prejudice that you may have and trying to be conscious to work to keep that from affecting your representation. At a bare minimum, you've got to be comfortable referring to the client in the client's preferred gender and using the preferred name. Because even small inconsistencies, when you slip up, can prejudice a court against the client and strengthen the other side's legal position. So you really have to work hard and be conscious of that. Where it becomes necessary to educate a judge or opposing counsel or a jury about transgender issues, there's several ways to do this, and it will depend somewhat on where you are, the political climate, what's available to you. One of the most effective strategies that we found is with the use of expert witnesses. Depending on the type of case, this could be psychological professionals who can educate a court about gender identity issues. In a case dealing with child custody, it might be someone who can testify about the fitness of, or rather that that being transgender does not in and of itself make a parent unfit. And we've even had expert witnesses testify about how it's actually a positive thing for a child to see a parent who is being a good role model by living, honestly and openly. So that's been very effective in our cases. Other ways to educate a court can be the citing of social science research and briefs, and where appropriate, eliciting amicus briefs from organizations who work with these kinds of issues all the time. And in jurisdictions that allow for jury trials for family law cases, attorneys have had good results using voir dire to educate jurors about trans issues. Next slide, please. Throughout a case, it's really critical to have good communication with the transgender client. And it's also important when you're having this communication to be really respectful and sensitive of the person's personal information. While it might be perfectly appropriate to ask a client in a certain situation whether or not they've had a legal name change or a legal gender or sex change, it's probably rarely appropriate to ask them the details of their gender transition. That's another good reason why you need to understand these issues, and you also need to understand the law in your jurisdiction to be able to really make sure that you are only asking what's relevant. Okay, Jennifer, I think are we up on my time now?
Yep. If you,
okay,
yep,
I'll turn it over to Jennifer now. Thank you.
Great. Thank you, Ben. Thanks. The focus of my remarks is legal recognition of gender transition. And can you advance the slide, Derek? To provide some context, it's worth mentioning that the International Professional Organization for Transgender Health, called the World Professional Association for Transgender Health, has promulgated medical standards of care for supporting a transgender person's transition from their assigned birth gender to the one consistent with that person's gender identity, also sometimes referred to as a person's brain sex. The medical standard reflects an individualized process of transition supervised by a healthcare professional and includes social role transition as well as, depending on the individual circumstances, hormones and, for some people, any range of available confirming gender transition surgeries, including, for example, TOP, meaning breast and chest surgeries, including removal and reconstruction, facial feminizing surgeries, as well as a range of genital surgeries, including, again, both removal and reconstructive surgeries. It's important to recognize that the approach of the standards of care is that surgery is not essential to transition, and for people whose transition does require surgery, there's no single surgical procedure that constitutes either sex change surgery or sex reassignment surgery. A range of procedures may satisfy a surgical standard. So with that medical background in mind, I'll focus on legal name changes and documentation changes, which form the basis for most people's legal steps in transition. Next slide, please. Turning first to name changes, many but not all states have both common law and court-ordered name change. Doing a common law name change is obviously an easier process. It simply requires someone to take and use a different name. Unfortunately, given evolving technology, it's typically a less satisfactory way of achieving a name change, since clients often can't get the documentation they need to reflect the new name. On the other hand, it can be an effective way for some people to get employers and others to use a new name, particularly at the beginning of transition. Getting a court-ordered name change is typically not a burdensome process, however, and is what many clients seek. It typically involves payment of a fee, the filling of several forms, the filling out of several forms, publication where required, and occasionally a court appearance. Issues to consider in doing name changes for transgender clients include whether to seek an impoundment order and special circumstances which may justify waiver of publication, including, for example, where a person's safety or job security could be compromised by publication. A recent experience in Boston highlights reasons to impound a name change, even when a client may not prioritize impoundment at the outset. So following a subway train accident here, reporters investigating the subway train driver's background discovered the name change and made the focus of press reports the driver's transgender identity rather than the safety and employment issues that otherwise might have been the center of the story. So think about impoundment even when the reasons for it may not be immediately obvious. The good news is that the standard for granting a name change in all jurisdictions is low, typically just requiring a demonstration that the name change is not being pursued for fraudulent reasons. Next slide, please. In addition to name change, many transgender clients seek to change the gender marker across a full range of government-issued documentation. Next slide, please. Typically, the documents that a transgender client seeks to change include the birth record, other state records such as driver's license or any other kind of state-issued documentation, and federal records including, for example, passport, Social Security documentation, Medicare records. Next slide, please. States vary in their methods for making changes to the gender marker on birth records. Obviously, you have to check the standard in the state in which you practice in order to assist a client in changing their birth record. While some states have a statute that specifies both the standard for changing the marker and the method, other states determine the standard and method for changing the marker based on regulatory or administrative law. It bears mention that some states don't allow a change to a gender marker on a birth record for a transgender person under any circumstances. Tennessee and Ohio are examples of such states. And just to be clear, that doesn't mean, though, that the person can't get documentation of the gender transition. They may just not be able to get the birth record changed in the state in which they were born, which I'll turn to now. Next slide, please. Your practice may, of course, include changing the birth record for clients whose records were issued in the state in which you practice, as well as clients who were born in another state or in another country. In representing clients born in another state or another country, you may need to seek a court order or declaration of the client's change of sex from a court in the jurisdiction in which you practice. This often involves the filing of an equity petition that cites the in-state standard, the fact that the petitioner meets that standard, that the petitioner was born in a state that anticipates the submission of a court order, and that the petitioner has no remedy at law to secure recognition of the gender transition in the state in which he or she lives because of having been born out of state. Here, too, it's worth considering filing an impoundment motion along with the petition. In addition, I've found that it often requires some explanation that the order sought is a declaration of change of sex that doesn't order the out-of-state court or administrative entity to do anything, but is nevertheless a necessary and anticipated court order that will enable the client to secure an amendment to or change in an out-of-state issued document. I've found that judges are somewhat confused about the nature of the declaration and oftentimes view themselves in a limited role since they can't order an out-of-state agency to do anything. But that, of course, isn't the declaration that's being sought. A final important consideration to review with a client is the fact that some states issue only an amended birth certificate that leaves the fact of the gender transition obvious on the face of the document, while others issue a new certificate, leaving the original birth certificate sealed or confidential. Next slide, please. While I obviously can't review the birth record change standard in all states, I put these two statutes up, one from Alabama and one from Iowa, as examples simply to make 2 points. So first, most states, though not all, do require a demonstration of a person having undergone a surgical procedure in order to change the birth record. My practice suggestion in terms of documentation to provide is that less is more. That for most clients it makes the most sense to get a letter either from a surgeon or their primary care provider, depending what's anticipated in the state rule, that tracks the language of the statute. Detailing the nature of medical procedures is not typically required, and a letter that says the person has undergone surgery for purposes of sex reassignment should be sufficient. Moreover, there's no reason to presume that any specific form of surgical procedure is required if not otherwise indicated by rule. And the second point here to make is that the Alabama law is a good example of a law that anticipates a court order and that may be cited to an out-of-state court as the basis for obtaining an order that can then be submitted, for example, to the appropriate Alabama state agency for non-discretionary change of the record. Next slide, please. Finally, this is a list of the most commonly changed federal records. The rule for changing passports was recently changed to reflect the contemporary medical approach to gender transition. According to Department of State rules, no surgery is required. And a letter confirming the fact of someone having undergone gender transition is sufficient for getting a passport that reflects the person's current gender. On the other hand, Social Security rules do require a letter confirming the fact of someone having undergone a specific form of medical care. And finally, it's worth mentioning that the Social Security and Medicare records are cross-referenced so that a change in the Social Security marker typically triggers a change in the Medicare records, which is not always obvious to a client. That cross-referencing, however, does not happen across all federal documentation, and that's also worth mentioning. So one final note, which is that completing gender marker changes on the broadest range of documents that are held by a client is the best way to ensure that should a question ever arise about a person's sex in, for example, some family law context, that it will be determined, that the person's sex will be determined to be that consistent with the individual's brain sex, rather than automatically being tied to the attributed birth sex. However, documentation of the gender transition on government-issued documentation should not be essential to that determination. So next up, we will turn to Shannon, who is focusing on family formation and protecting transgender clients' parental rights.
Great. Hi, everybody, and thanks to GLAD for putting on this wonderful event. So I'm going to talk about two topics: the rights of transgender parents and then custody disputes involving transgender children. So can we go to the next slide? I'm going to talk first about transgender parents. So the most important thing I could convey is that in all cases, a transgender parent is going to be much better off if he or she establishes legal parentage through court action, through a parentage decree or an adoption decree, and that is that's as opposed to relying on a birth certificate, having a name on a birth certificate, for example, or just relying on the fact that the person is presumptively a parent under their state law. You know, having that legal judgment is really critical because it will prevent a lot of problems down the line, and it is absolutely essential to be sure that that person's parental status is going to be respected in other states. You know, it's very clear that states have to give full faith and credit to parentage judgments and adoption decrees from other states. So a state is going to have to recognize a court order stating that a transgender person is a legal parent or an adoptive parent, even if that person would not have qualified as a legal parent or would not have been able to adopt a child in the forum state. So really important to get those court orders. So of course transgender people can become legal parents in a variety of ways, and one is through biology. You know, for example, a woman may give birth to a child and then later on transition to male and be living as a man. A man may biologically father a child and then later on transition to female and live as a woman. And that's fine. You don't automatically lose your parental status simply because you've transitioned from a man to a woman or vice versa. Let's move to the next slide. That said, though, it's also important to be aware that in custody disputes, some courts have taken the really extreme step of terminating a transgender parent's rights based on the erroneous belief that somehow simply being exposed to a transgender person could be harmful to a child. That is not actually true, but some of these cases there has not been good expert testimony on that fact. So we have a 1986 decision from the Nevada Supreme Court, for example, that terminated the parental rights of a male to female transgender parent who had fathered a child in the context of a heterosexual marriage before she transitioned. The court held that the transgender parent, quote, was a selfish person whose own needs, desires, and wishes were paramount and were indulged without regard to their impact on the life and psyche of the daughter. And a similar decision from 2007 from Kentucky. So these cases really highlight that transgender parents who transition after they have become parents may face some rather harsh judicial scrutiny. And if you're advising a parent in that situation, they really need to be very careful about how they disclose their transgender status to their children. And if possible, they should be doing that under the advice of a therapist with expertise in the area and really document that they're following that expert's guidance. A transgender person may also biologically procreate after undergoing a gender transition, and this is becoming more common. And that's by using sperm or eggs that the person harvested before undergoing medical treatment. You know, for example, you could have a female to male, a transsexual man who could use his harvested eggs to have a child with his female partner by using a sperm donor and then implanting the fertilized eggs and the female partner giving birth. Or you could have a male to female transsexual woman could use her harvested sperm to have a child with a female partner. Those are just a couple examples. Obviously, there's all kinds of different permutations. But the important point legally here is that most states have not addressed how to determine the legal parentage of children that are born under those circumstances. So again, it's really important to get either a judgment of parentage or an adoption that clearly identifies both partners as the child's legal parents. Then, of course, there's ways other than biology to become a legal parent. An obvious one is through adoption. Right now, there's no state that bars transgender people from adopting, although, of course, in practice, a transgender person may encounter informal bias or discrimination. There's actually one state, California, that bars discrimination against transgender people in the adoption arena, and we hope to see more of those. So a transgender person who's in an unmarried relationship with another person can use a second parent adoption or a co-parent adoption in any of the states that permit such adoptions, you know, just like anybody else. Or transgender people who are married, you know, may be eligible to obtain a step-parent adoption or do a joint adoption with a spouse. Another way that a lot of transgender people gain parental rights is through marriage. You know, for example, a transsexual man who marries a woman will be presumed to be the legal father of any children who are born during their marriage. A transsexual woman may become a legal parent through marriage if she's married to a female partner in one of the states that permit same-sex couples to marry, and then they have a child through alternative insemination. Or a transsexual woman may be married to a man, and the couple could have a child through surrogacy using donated eggs and the husband's sperm. So if you're an attorney and you're advising individuals or couples in that situation, it's really important to know the law governing assisted reproduction by married couples in your jurisdiction and be really sure that couple is following the letter of the law. But there's a whole other dimension to this with transgender clients, and that's that you also have to really think about what would happen if a transgender person is not a biological parent and has gained their parental rights based solely on a marriage. You know, what's going to happen down the line if that marriage is found to be invalid? So in some cases, a spouse or a former spouse is going to challenge the validity of a marriage in an effort to deprive the transgender person of parental rights. This doesn't happen a lot, but unfortunately it does sometimes happen, and when it does, it can be very ugly. So if you're representing a transgender client in a case like that, it's really important to defend the validity of the marriage. Some people are tempted to just give up on that issue, but the invalidation of the marriage could threaten the parental rights of the transgender person, so you really have to fight that. And then attorneys in these cases should also be aware that even if the marriage is found invalid, there are almost always a number of other arguments that can be used to defend the transgender person's parental rights. You know, for example, in most states we have either statutes or court decisions that say that even if a marriage turns out to be void, the invalidity of the marriage does not retroactively affect the status of any children born to the marriage, that it doesn't go back and strip either spouse of parental rights. And then in some states, for example, courts have held that a step-parent adoption likewise isn't retroactively invalidated by a later finding that the marriage is invalid, but the adoption itself is still valid. And then, of course, estoppel arguments can apply as well. If someone has agreed to marry a person knowing that they're transgender, they may be stopped from challenging either the marriage or the parental status of the transgender parent. So if you're an attorney representing a transgender parent in one of these cases, you really need to be vigilant about making sure you are presenting and preserving every possible argument for protecting that parent's parental rights, even if the marriage is found to be invalid. All right, let's go to the next slide and skip over to the topic of custody disputes involving transgender children. To say we're living through an amazing time. We've got more transgender children coming out to their parents, more parents being supportive, and this is really the first generation of transgender children who have a chance to grow up with a lot of parental nurturance and support and to really live their whole lives authentically. And what we're seeing in the medical profession is that medically doctors and other providers now recognize that transgender youth, transgender teenagers can be spared the pain and the trauma of going through the wrong puberty by being prescribed hormone blockers. It delays puberty. It gives the young person a chance to reach an age at which they can make their own informed decision about whether to begin cross-hormone therapy. So I will just say real quickly that these cases are generally fine if the parents are on the same page, but if the parents are in different places, it can lead to very bitter custody disputes when one parent is supportive and the other is not. And the key thing here is that the supportive parent has to obtain professional medical guidance, seek advice from a therapist with expertise in gender identity issues, seek advice from an experienced pediatrician willing to work with that therapist, and really document every step. And then when you get to court, you're going to have to educate the judge and at the earliest opportunity present expert testimony about these young people because most courts are not familiar with them. I'm going to stop there and turn it over to my wonderful colleague, Polly Crozier.
Great, and I'm actually just going to jump in for 1 minute, Polly. My apologies to you, to remind anyone listening that if you're interested in sending in a question to me, which I'll start to pose to presenters after Polly concludes, that you can use the chat box and send in your message. So now, Polly, it's you.
My name is Polly Crozier, and I'm going to talk about transgender parent rights after relationship dissolution, particularly practical tips for representing a trans parent in a custody dispute. When I first meet with a trans client, I consider what parental status does my client have. As Shannon mentioned, significant differences exist depending on whether they're a legal or an equitable parent. Legal parental status is much stronger, and a trans legal parent stands on equal footing, and the analysis really is going to be best interest. If my client's an equitable parent, there's a significant legal power imbalance that we need to address. The trans parent is not on equal footing with the legal parent. They first have to establish that the equitable relationship exists, and then if there is one, the issue is whether continuing it is in the child's best interest. For me, the parental status really permeates the whole case, and I need to be aware of it from the outset, starting with the intake and the client counseling. Next slide. Now, with trans equitable parents, I get much more detail about the actual caretaking the trans parent has performed for the child throughout the child's life. I educate the trans parent about the stress of litigation and the costs that are involved, because with the equitable parent litigation, it's so fact-intensive and the stakes are extremely high that they really need to know that from the outset and be prepared and to pull on those support systems to make it through the litigation. Next slide. And my next critical question when meeting with a trans client about a custody dispute is, what's the posture of the case? Is this a original custody action immediately after a relationship dissolves, or is this a later modification? If it's an original action, the standard is best interest. And if it's a modification, the issue is really, first, whether there's been a material and substantial change in circumstances. Regardless of the posture of the case, I think the lawyer's duty is really to determine, how are the parties communicating, and will the client's transgender identity or transition be a factor in the case? Sometimes it's totally irrelevant. Sometimes it's really the central issue, and the client's really going to be under attack. If that's the case, I explicitly ask the client, what support systems are in place for you? How can we get support systems in place for you? How does the client think we should address the attacks? They know the other person the best. They know themselves and the situation the best. I get an extremely detailed history of the parenting so I can rebut attacks on his transgender identity and any nexus that might have with the parenting. I get a detailed sense of how the kids are doing, marshal data from people other than the client, doctors, teachers, figure out how well the children are doing and try to rebut any transphobic arguments about the children. And I think it's really critical to gather resources early on. Case law, law review articles, social science research to educate everyone involved in the case. I think the bottom line that family lawyers need to remember is that, next slide, that transgender identity really should be irrelevant to the best interest analysis. And a person's transition should not be a material and substantial change in circumstances if that's what's happening in the family. There's not a lot of research out there on trans parents and children. What research there is shows that children are not harmed from having trans parents. There's not a nexus between transgender identity and the ability to parent. And without that nexus, there's really no justification for considering trans identity or parents' transition in the custody dispute. Now, there is a lot of evidence that what harms children is being in the midst of a contentious struggle between parents and getting cut off and alienated from a parent. It is possible that there are legitimate concerns about the client's parenting ability that are distinct from their gender identity. That happens all the time with our clients. I think the lawyer needs to identify that early on and proactively work with the client to get that person the assistance they need, whether it's parent education classes, court guidelines about parenting plans, therapy, or substance abuse treatment, whatever is appropriate. So even though the trans status should be irrelevant, we all know there's pervasive discrimination in the court system. The National Center for Transgender Equality and the Gay and Lesbian Task Force recently published the National Transgender Discrimination Survey, which I recommend you all take a look at. 38% of the respondents identified as parents, and 29% of those people experienced an ex-partner limiting contact with their children. 13% of respondents with children reported that courts limited or stopped their relationships with children. One case example, Christian versus Randall in Colorado, a father tried to take custody of his children who were in the custody of their other parent, a trans man. The trial court flipped custody because of the transition. The appeals court, however, reversed, holding that it was improper for a court to consider the conduct of a custodian that does not affect his relationship with the child. It's very important to recognize as lawyers, even though it shouldn't be a factor, that gender identity is often used in a discriminatory manner and that we have to address the discrimination head on. So how do you do that? I think oftentimes, next slide please, the easiest way to do that is to ask for the appointment of a guardian ad litem to investigate and report on the children's best interest and appropriate parenting plans. I think when you have a transgender client, you need to be extremely careful about, first of all, what type of guardian ad litem would be helpful, and then who that actual person is. In my mind, no guardian ad litem is better than a bad guardian ad litem. The report of a guardian ad litem will be very influential. You don't want to take someone off the court list. You want to make sure that you get good recommendations, get the person's resume, call each potential guardian ad litem, and ask them a very standard set of questions, such as, their experience with transgender parents, their experience with transgender children, the basic questions, obviously, about what their process is. Are they open to education from the lawyer and the client? Really try to vet the people and make those suggestions to the other side that are good guardian ad litems. And once you select that person, get off on the right foot. Be responsive. Educate the guardian ad litem. Attend the first meeting with the client to make sure that the focus of the investigation is appropriate. Keep close tabs in the investigation. And I think you need to be aware that if a guardian ad litem turns out to be biased or to be making transphobic recommendations, there are things you can do. You can ask for a clarification of the appointment to target the issues back to the focus, which should be the children. You could consider a motion to remove the guardian ad litem. You could also try to hire an independent expert to review the GAL's report and make recommendations so that you can rebut those recommendations. Another way to combat discrimination is to be proactive and vigilant in discovery. Don't respond to discovery that focuses and attacks your client's trans identity. It's irrelevant. It's inappropriate. If necessary, proactively seek a protective order to point out the discriminatory tendencies of the other side and shield your client from the transphobic requests. Proactively seek a motion in limine before a trial or an evidentiary hearing to protect your client from improper questioning and to protect the record. I think also as lawyers need to be aware that discrimination, next slide, often appears in the form of limits on a client by the court or the other parent. Often the parent will try to restrict your client's parenting time. If there are those time restrictions, you need to be proactive and address them right away so that the negative status quo doesn't stand for very long. And if the other parent at the court tries to limit the trans parent from expressing his gender identity before the child, I think you need to be consulting some expert advice, the child's therapist, your therapist, experts, to make sure that what you're doing is child-centered, but also to address the restrictions. Because your client does have a constitutional right to freedom of expression and to privacy and personal matters. And since there's no proven nexus between gender identity and parenting, a restriction on your client's gender identity really should be impermissible. And I think, in my mind, you should also be aware that discourage your client from suggesting restrictive orders to somehow get, to appear sensitive. It really shouldn't be the matter of the court to restrict your client's gender identity. That's the business of the therapist, the people who are addressing the child's needs. And that really shouldn't be proactively offered to the court. Above all else, I think one should consider trying to stay out of court into using ADR, such as mediation, where your client has more control over the final result, it's more private, more cost-effective, and potentially less discriminatory. That's obviously only wise if there's really no giant power imbalance between the parties. In any event, I think the bottom line is your client's gender identity really shouldn't be relevant, but it often is. Be on your toes, be prepared to educate, and to resist discriminatory pleadings and orders. Thank you.
Great. Well, thank you so much to all of our panelists. That was, really very informative. And we have some questions that have come in, so I want to pose them to any or each of you. I'm getting a little feedback here too. So first of all, there was a question that came in asking about what is the recommended approach to take in representing a transgender person in a relationship dissolution case that doesn't involve contested issues of custody around kids, but rather includes matters relating to division of assets and future support, et cetera. So I don't know if that's actually Ben or Polly. Do you want to comment on that?
What's the question, Jen? Is there a specific question about?
What approach would you take? Would you recommend in representing a transgender client in a divorce case where the case is being tried over financial issues like earning capacity and division of assets and is not focused on child relationship issues?
I could imagine some of the arguments a client would need to be aware of is if the other side's going to make some allegation that there's been dissipation of the marital estate based on uninsured medical expenses or medical costs related to the transition. I think that would probably be, I'd be prepared to rebut that very strongly. And that also, but Ben, do you have any thoughts?
No, that was actually the one thing that I thought of too. But otherwise, I don't think it would be relevant to the action.
Okay.
Yeah.
Just trying to make sure that it's clear to everybody that that's not really a relevant factor.
Okay, great. Super helpful. And Shannon, can you address how someone who is doing an adoption should address the fact of a parent being transgender? Does the person have to disclose their transgender status in that context?
Sure. I think most attorneys would highly recommend to a transgender client that he or she disclose being transgender in an adoption proceeding in order to prevent anyone from being able to come back later and challenge the adoption on the ground that that information was not in front of the court or the social worker. That said, though, it is ultimately an individual decision, and some transgender people prefer to remain private about that. And one could certainly make a good argument that it's not irrelevant in any way to the adoption. I will say, too, though, even if the person would rather not disclose, it's possible that the information will come out through a background check, including, for example, a fingerprint check. So you may be taking some risk of, ending up looking like you were withholding relevant or what will be viewed by other people as relevant information.
Good, thank you. So another question is, in states like North Carolina, where second parent adoptions recently were rendered null and void, are there any particular concerns relevant to transgender parents that would be different from gay parents, gay or lesbian parents? Maybe that's to you, Shannon.
Right. Well, if a transgender person adopted in North Carolina based on a heterosexual marriage, then they will not be in any way affected by that North Carolina decision. But if a transgender person is in, for example, a same-sex relationship or an unmarried heterosexual relationship and relied on a second parent adoption in North Carolina, then unfortunately they're in the same boat as anybody else. All second parent adoptions in North Carolina are now subject to being voided.
Yeah. Okay. And next question, Ben, this is largely to you, but I think anyone can follow up and after you get a chance to respond. And that is, the question is about what legal arguments would be damaging to the community as a whole that attorneys should typically try to avoid, especially where there may be indeterminate law. I realize it's kind of somewhat vague and broad, but do you want to speak to that?
I can give an example. I can think of one example right off the top of my head. There's times where I can see in, say, a divorce action where it might actually be in your client's financial interest to claim that a marriage was void because of that client's, or even because of the other party's transgender status. That would be an argument that, in my opinion, should never, ever, ever be made. Because even if it might help your client, it would be devastating to trans people in that jurisdiction who are married.
Okay, good. Helpful. Anyone else want to respond to that?
Well, I think that it's oftentimes, if a trans legal parent, if there is another person who's on an equitable parent on the other side, it might be attractive to use that legal parent status as a sword. And I think it's important to remember that children, in all respects, don't know the legal status of anyone, and really, should work to support both parents' rights, even if temporarily the issues are difficult between the parents.
Good. And here's a question for you, Polly, which is not directly connected to that issue, but the question is, might a GAL's discriminatory conduct towards your client or towards a transgender child be an ethics violation? And kind of more broadly, what would you recommend doing in the face of either a discriminatory report or questions or evaluations that suggest bias from GAL?
It's a great question. I think we talked a little bit about how to do it within the context of your case, but then I think you need to, if it's really, if it's really obvious, and you really need to take additional steps, such as report. Most likely, a clinician or a GAL will be licensed in some way, reporting that person to the licensing authority, making a complaint to, the BBO if it's an attorney GAL. That I do think or there are oftentimes state organizations that regulate GALs and promulgate guidelines for them to abide by. I think it is important to take that next step, and sometimes you can do it anonymously to let the greater community know that this person is really acting inappropriately.
And what do you see as the benefits or drawbacks of alternative dispute resolution in custody disputes where a parent is transgender? I know you recommend that as an approach.
Well, I think that, it really, obviously, ADRs, you really have to know that it's good for your client. I think that if there's a big power imbalance, so if the assault from the other side is so significant and so negative, it's not going to be a good option. Although then again, I have definitely heard of stories where people use mediation to try to get out of such an abusive situation because it can sometimes be faster. So I think you really need to weigh the power imbalance and whether you can address that. And if the power imbalance is too great, to use litigation. But I think no matter what, that your client should be guided by counsel throughout the mediation so that they know the appropriate contours and what is, so they have that legal support. But I think that, it's faster. It oftentimes gets to a better result. and that if the parties are able to communicate and remain child-focused, it's a really good option, particularly in the days of overburdened courts that are slow-moving, and when the court system, I think, there's a greater likelihood of discrimination there than in your own private setting.
Good. Shannon, this is to you. And how do you recommend addressing conflict between parents around allowing a child to express a cross-gender gender identity, where a child may not yet have connected with any kind of mental health support for that?
Right. Well, I think that it's really important to educate the court, because most judges are going to be very initially, I think, shocked and unprepared to deal with the idea that there are children, young children who are maybe 5, 6, 7, 8 years old who have a strong cross-gender identification, and they're going to really need some expert testimony to help them understand that this is a very real condition. And one important piece of information that people should really know in these cases is that we do actually now have some very persuasive data, social science research, that shows that children are terribly harmed by attempts to repress their gender identity and to try to force them to be someone who they're not, and it dramatically increases the child's chances of attempting suicide, in fact, by a factor of 5. I was involved in a recent case with a very moderate judge who I think initially was just taken aback by this issue, and after listening to expert testimony and reading the research on this issue, he actually said in open court that he was very humbled by dealing with the situation and recognized that that this is a tremendously vulnerable child and potentially a life and death situation. But I think that's the kind of information that you need to make sure that a court has.
Great, helpful. And the flip side, I guess, of that question, sort of, which is if you're representing a transgender parent in a custody parenting schedule matter, and you've got an older child who has expressed an interest in having little or no contact with the transgender parent because of discomfort or anxiety or something around the parent's transition, does anyone have recommendations about how to best address that issue in representing the transgender parent?
Well, I would guess Polly has something to say about that, but real quick, this is Shannon again. I think, again, it's really critical to have expert testimony. And there are many now psychologists who have extensive experience working with these families and who could come in and explain to a court that with the proper support, this is something that a child can easily come to understand, and it's not harmful in any way. But that, on the other hand, losing contact with that parent is going to be devastating to most children. Those parent-child bonds are so important for a child's long-term health and well-being. And coming to grips with the parent being transgender is eminently doable with the right kind of family and counseling support, and really in a short amount of time as well. It's not something that's going to take a really long time. But losing a parent, on the other hand, devastating for a child.
Yeah, and Polly, do you want to, I'm sorry, I've just cut you off. I'll let Polly add to that.
Yeah, I think that if the child is already is having negative alienated feelings, I think you really have to step back and look at what the other parent is telling the child, and hopefully get some kind of court order or clear message to that parent to make sure that the messages to the child are positive and the child's relationship with the trans parent is fully supported. Because oftentimes those messages don't arise out of nowhere. And I think for the child, I mean, they really have to, folks really have to address that breakdown immediately and put support systems in place to address it before it goes much farther, and have therapy for the child, maybe some support for that relationship, because you don't want to let that alienation go on.
And I think we may have time, this may be the last question, and it is whether states with state DOMAs are determining that marriages involving a transgender person are unlawful marriages, even where the transgender person has had a gender marker change prior to the marriage. Shannon, you want to take that?
Sure. No, we don't have many cases to that effect. There are a handful of courts that have come to that conclusion, but we have significantly more trial court decisions rejecting that theory, and it's certainly something that may come up in any challenge to the validity of a marriage in a jurisdiction that has a Defense of Marriage Act. I think we have very strong and persuasive and compelling arguments that state DOMAs and certainly the federal DOMA were never intended to and do not properly apply to a transgender person who has legally changed his or her gender and then entered into an opposite-sex marriage. So I think the better and stronger and ultimately to most courts more persuasive arguments are on the side that DOMA does not apply to those marriages.
Yeah, thanks. And I would add into that too, since the question was framed around whether that assessment is made disregarding the gender marker changes, but I want to underscore what I was saying in my remarks, which is that the gender marker change is important and strong evidence of the fact of the gender transition, but even where somebody hasn't secured the changes in the designation, as long as somebody can still satisfy the standard for gender transition, that their transition should be respected by courts as a legal matter. And I think that's the right description, which is that it is certainly more consistent with the dominant case law in that context. So I'm going to thank you. I want to thank the panelists and everybody who was a part of this webinar. I think it's been very helpful and informative. And I want to let all of the attendees know that after the webinar ends, you'll see a short survey, and we would very much appreciate feedback on the information presented today. The webinar was recorded, and it'll be available at www.glad.org starting on Friday if you'd like to watch it again or share it with anyone else. And also, there were a number of questions that came in about whether the materials that were covered, the cases and such that were addressed during the webinar will be made available. And I want to let everyone know that this webinar is part of a broader project at the Transgender Rights Project of GLAD to provide more resources to family law attorneys to enhance capacity to represent transgender clients. And toward that end, we will be releasing a book, hopefully by the end of this year, that will incorporate all of these materials and more, and appreciate everybody's increased interest in providing legal services and legal representation of transgender individuals. So thank you all, and this is Jennifer Levi signing off.